Good morning, WTOB listeners. Welcome to For the Record with Greenwood Law. I'm Dylan Greenwood, along with Harold Eustache. And today we're going to be talking to you about potential things that can happen in a case, specifically deferred prosecutions and conditional discharges. So frequently, when somebody calls us up to talk to us or they come in to meet with us, one of the very first questions that's asked is, well, what's going to happen to me?
Right.
What's going to shake out with this? I wish we had the crystal ball. A lot of things that we talk about, we base off of our experience of seeing a lot of things in court over and over and over again. But there's always that caveat of, I can't guarantee this specific thing is going to happen, but this is typically what we see.
Mm-hmm.
But that being said, every case is unique. It has its own individual set of facts. Every person that walks in and talks to us has their own individual unique story. And that's something that I think we really take serious when we talk to people who want to take the time to talk to us. We try to understand what that is, what's going on in each set of circumstances. Because the reason is the more we get to know that, the better able we are to figure out the direction to go in a certain case. One of the first things that I ask, and I think you do too, is, well, do you have any kind of criminal history? Because if someone doesn't have a criminal history, there are a lot more options on the table for a potential disposition in a case versus someone who does. Now, that being said, there's a difference between a criminal history that's all traffic tickets versus a criminal history that's littered with felonies and all kinds of misdemeanors and whatever else. One's easier to deal with than the other, as you might imagine. But today we're going to talk about deferred prosecutions, conditional discharges, and typically speaking, these are outcomes that usually are reserved for people who don't have a record. That is not always true. There are ways around that. That's why it's good to have an attorney. But there are a lot of different options on the table, aren't there, Harold?
There are a lot of different options, and this is used quite a bit in courtrooms. It's part of the whole sort of plea bargaining process between defense attorneys and prosecutors. So as Dylan alluded to, when we're talking to a client or a potential client or a client about the story of their case and what happened, we also like to know who they are. And part of the reason sometimes, I'll ask them about, what they do for work or where they're in school or what their family's like. And sometimes people can be caught off guard by that. But a lot of times we're asking that because one of the provisions for deferred prosecutions is really convincing a prosecutor that this is a person that's not going to reoffend. You won't see this person in court again. So the more that you can know about their life and say, here are the kind of characteristics this person has, it goes to helping them. But these deferred prosecutions are dictated essentially by statute in North Carolina that gives prosecutors the ability to do these kinds of agreements, but they can range in the way that they are done from county to county, from DA to DA. There's a wide latitude of what someone's able to do. I know when I was a prosecutor, I would do a lot of what we call back of the shuck agreements, where these shucks are these files that we have that the clerk's office keeps, and you could write on the back of it, defendant will complete 15 hours of community service for voluntary dismissal, sign my name, and that would be the end of it. Those aren't done here as much. I'm sure they're done in other counties. And those are allowed by statute. You can do that. But it's generally in a deferred prosecution, the general way for our audience to think about it is the defendant is giving something up in order to get something. So they're either giving up an admission of guilt, they're giving up some community service, they're giving up a driving course, something. I mean, I've seen it be, write an apology letter. I've seen all sorts of stuff, write a speech, be done, and they're giving something up of their time or energy in order to get the outcome that they want.
Yeah, and it really can range all over the place. It's a blank slate, and that's why it's important to get to know who we're talking to. I don't know how many times in trying to figure out what's going on with the case, if someone's candid with you in the ways you want them to be, telling you about what's going on in their lives, then a lot of times you can really pinpoint what led to a certain issue. Why did someone steal something from Walmart? Why did they get involved in drugs? I don't know how many drug cases, for instance, I've seen that were kicked off by a family member close to them dying. Mm-hmm. Or, some sort of extenuating circumstance like that, where if we have proof of that and we can say, hey, look at this pattern of events in this person's life, it's easy to see this is what happened. Here's how we're taking care of it. Let's do something about it. This isn't their normal course of action. And like you were saying, Harold, is that, the DA is making an investment in you and identifying and saying, listen, we think that this is a one-off thing. We're willing to take the chance and give you an opportunity to rectify it. Because generally speaking, but for the most serious of crimes, the law has built-in avenues for you to get a second chance. Mm-hmm. Some of them, depending upon the type of charge, are compelled by the law. You have to get them because of things that we have identified in our society, things that we've identified in North Carolina as being worth it to give someone that opportunity to try and rectify. And a couple of those are different types of conditional discharges, specifically involving drugs, and prostitution is another example of it. And the drug one is what we commonly refer to as a 9096. And for certain offenses, even all the way up to some felony offenses for drugs, a court is compelled to give someone the opportunity at a conditional discharge as long as the person receiving it is okay with it. If they're not, they can take the judgment. They say, listen, I don't ever want this conditional discharge, I just want to take the judgment. That is not smart, because how many times will a judge put someone on probation that will be sufficiently similar to what they would have required them to do on the conditional discharge?
Right. And of course the outcome is different, because at the end they would have a conviction versus not.
Yeah, and you successfully complete a conditional discharge, you successfully complete a deferred prosecution, it ends up as some form of a dismissal. The reason why I say some form is there are multiple types of dismissals in North Carolina. There's voluntary dismissals, there's courts dismissals, there's deferred dismissals. There's different types. You may just think, oh, well, dismissal's dismissal. No, they actually can trigger different things
right
on down the line.
They can.
Especially when it comes to expunctions.
Right. And so just for our audience, I know we've thrown around deferred prosecution and conditional discharge. Just to give you guys an understanding, they both kind of lead to generally dismissal, but they're kind of set up sometimes a little different. So deferred prosecution is a person that's charged with an H.R.I. felony, or is under statute, an H.R.I. felony or a misdemeanor. While they're charged, they can be placed on this deferred probation. And deferring prosecution means essentially almost what the title of it is. We're going to hold off on prosecuting this case and see if this person can satisfy some conditions. And if they do, then the state will no longer prosecute, which ends in a dismissal. In order to do that, the prosecutor has to notify any victims that there are. There's a victim's rights, which we can get into one day, but the prosecutor has to notify that victim of this defendant doing that. It has to make sure that the person has not been convicted of any felony or misdemeanor involving moral turpitude. The defendant has not been previously placed on probation, and the defendant is unlikely to commit another offense other than a class 3 misdemeanor. So that's sort of a weird one where it's really, really subjective there. And that's why we get into some of this stuff that Dylan and I have been talking about what a person's life is like. But as far as a conditional discharge, that is a person that pleads guilty or is found guilty. And at the time of judgment, essentially they are given this conditional discharge, meaning there's a condition placed on your probation, basically,
right.
and the case will be dismissed.
And it is at the time that judgment should be entered, but that judgment does not go through.
Right. That is important.
It's pushed off. And I know that's, and I'll even admit as an attorney, that whole concept of when a judgment locks in versus when it goes to another place in time, compared to when someone pleads guilty, found guilty, or whatever else, that's a weird concept to grasp.
It is, and we have to explain this to our clients all the time, and it is cumbersome to explain that we're going to go in court and you're going to plead guilty to this, but it's going to be dismissed down the road. And sometimes people have a tough time wrapping their head around that, but it is something that we kind of have to do.
Right. And so, on these types of conditional discharges, as long as someone does whatever the court conditions them to do, then it is going to get dismissed at the end of the day. Now, a court can put any types of conditions. It's not limitless what a court can do. Don't think that. But, typically speaking, it may be some form of substance abuse treatment, community service is common, classes of some sort are common. Like, for instance, in Forsyth County, we've got shoplifter courses, we've got drug courses, we've got stuff related to involvement in gangs. There used to be a John school for people who would solicit for prostitution. I mean, there's all sorts of these types of educational opportunities. If there isn't a concrete one available, that's when we as attorneys try to get creative in the process and create someone's own educational opportunity to try to address
we do that all the time.
Whatever's going on. So there's a little bit of sometimes it's a bit of an art to try to get something nailed down. But an individual can either be placed on unsupervised or supervised probation, and that can be a big difference in somebody's outcome, because if they're on supervised probation, they have to appease a probation officer, they have to pay supervision fees, they've got to be able to pass drug tests, they've got to be able to subject themselves to warrantless searches and seizures. I mean, there's all sorts of things that trigger at that point, just like you would be on probation if you were convicted. So that's always our point to people that we're talking to. If we think there's a potential you could get convicted and you're going to be on probation anyway, why not do probation to get something at the end of it rather than do probation and end up with a conviction? Yeah, you get something, but you get a conviction. Right.
I know earlier you had alluded to some of the conditional discharges that are compelled by statute. One of them was prostitution. Can you explain how that one works? That's an interesting one.
Yeah, that one is an interesting one. So for first-time offenders who have been caught being prostitutes, there's a possibility, as long as they consent, the court is required to put them in a conditional discharge. And that conditional discharge has to last for 12 months. It requires certain conditions occur. So a lot of it has to do with like vocational training. So again, the court is trying to address the issue that potentially led someone to be involved in prostitution. So the court kind of taking a bit of a paternalistic vibe is saying, hey, learn a legitimate profession, get away from this dangerous activity of prostitution. And so submitting to drug tests is a common condition of probation. You can't possess a firearm. You have to attend certain number of counseling sessions to address whatever led you down that path. So I think this is a great program.
Me too.
In the sense that a lot of people who go down this path of going to this profession of prostitution, there are a lot of things that have happened in that person's life typically to get them to that point. There could be a drug issue, there could be a human trafficking issue, there could be issues at home, abuse, whatever it is. There are any number of things. It's limitless what leads a person there. But a court tries to figure that out through this conditional discharge and help that person, but it's help with teeth, because if they don't complete it by the end of the 12 months, then they can be convicted for prostitution.
Yeah, I think it's a great thing because, a prostitution conviction on somebody's record can really affect their life. And as you said, I mean, there's so many things that could lead down to the road of somebody being involved in that. And I think it's part of the court and the legislature trying to look at that particular offense and the people involved as victims, because a lot of times that they can be victims of many other types of offenses. So that's a great thing. The other one that we deal with very, very commonly is the 1996 one. As you said earlier, that deals with specific drugs. A lot of times we see those, they can be any of the drugs, but we see them a lot with marijuana. Just, we see them a lot with misdemeanor possession, and people that enter into this agreement to, get this thing off their record. And a lot of times people don't, people think, well, marijuana is not such a big deal, but it can have a lot of collateral consequences being convicted of something like a marijuana offense, even a misdemeanor marijuana offense. So it's important, if you are, charged with something like that, to really talk to your attorney about these kinds of deferred prosecutions or conditional discharges, because they can have a real effect.
Yeah, because specifically in Forsyth County, lower level drug charges like that don't necessarily have to get disposed of via a 9096. Right. Forsyth County has kind of created its own programs to address those issues, because there are, these conditional discharges that are set out by a court require someone to do a lot of stuff. And sometimes, something kind of a legal concept, a philosophical concept that we think about oftentimes in law is the concept of just desserts. Does the punishment really fit the crime? And so for a lot of, especially low level marijuana crimes, the 9096 can be looked at as overkill. Especially when a lot of its provisions are tailored to taking into account felonious activity as well. So I think our courts, our DA's office, defense attorneys have kind of realized, hey, there could be a smoother way to address what's going on with somebody here.
If you're just joining us, WTOB listeners, this is For the Record with Greenwood Law. I'm Harold Eustache here along with Dylan Greenwood, and we have been talking about deferred prosecutions and conditional discharges, ways to essentially get your case dismissed. Dylan, we've talked about several different kinds of formal and informal deferred prosecutions, but are there any other types of deferreds?
Yeah, Harold, there sure are. And under the formal route, the ones that are created by statute, we've talked about 9096s for drug prosecutions. We've talked about prostitution-related conditional discharges, but the other ones, there's one related specifically to toxic vapors. So people who are huffing, inhaling toxic vapors, it's very similar to a 9096, but it is its own specific conditional discharge for somebody. The reason why it's different from a 9096 is that it is not mandatory for a court to give that to somebody. It's in the court's discretion to do that. Then there's also drug treatment court. So statute allows for the creation of drug treatment court. And somebody can go through that where judgment isn't entered in a case, but somebody has to plead guilty, admit to what they're doing, and then they're placed in a intensive drug treatment program. And the court checks in with them regularly. Instead of court being a purely adversarial process, which is normally what happens when the attorneys sit at the tables, you got the judge and the witness and all that stuff, court becomes a bit more of a counseling process, checking in process, not as adversarial. And then there's also a conditional discharge available for first-time gang offenders under the age of 18. That one as well is something that is potentially compulsory for a court because someone's under the age of 18. As long as that individual consents entering into that program, then that is an intensive conditional discharge that's potentially available to somebody, and can do a lot to help, not just from the standpoint of helping their criminal charges, but potentially getting them out of a very dangerous situation. And the last one involves cyberbullying, which has certainly increased. It's a problem that has increased over the years with the internet. Frequently coming up on our program or being an issue on our program, or the good and the bad associated with the internet. Obviously, cyberbullying is an issue. And the cyberbullying statute actually lays out if you're under the age of 18, it's a class 2 offense. If you're over the age of 18, it's a class 1 offense. And if you're under the age of 18, then you have to get this conditional discharge as long as you consent to do it. And it's an opportunity for you to address the issue. The overall theme in all of this is you are addressing some issue that led you to do the behavior that you did that we find to be illegal. And if you address that and you do it successfully, then we're going to reward you for it. But up front, we typically want an admission of guilt, or you need to plead guilty. So there is a difference between an admission of guilt and pleading guilty.
Right.
And you have to agree to do all these things. And it's basically a form of a contract. It's a good way to look at it. So with that being said, Harold, you're like the grand poobah of probation violations and issues that go along with this. You ran that court for many years as a DA. What happens if somebody messes up one of these agreements?
So you kind of alluded to part of the answer earlier about a conditional discharge. You're pleading guilty or have already been found guilty, as opposed to a deferred prosecution where you're admitting guilt. So if you've already been found guilty, and these are the terms and conditions of your probation to do all these different things, then it's really a violation of your probation. It would be treated the same way as a probation violation would, and in which we can get into the details of that at a later time. But that's the way that would be seen. But with a deferred prosecution, where a lot of times you get a form and you're admitting guilt. So it's basically saying, I am admitting that I am guilty of misdemeanor larceny, for example. But you haven't been found guilty. You haven't been found guilty by a trier of fact at that point. Now, what would happen if you didn't complete that program is you would actually still have to be found guilty. So that case would still have to, go to trial. Your admission could be used against you. I think that there would be some pushback from defense attorneys about that admission. So it would be treated as any other trial where a person has potentially admitted that they did something, but can still have their right to a trial by a judge or jury or whatever, and it would be treated that way. So the way to think of it is deferred prosecution is kind of prior to being found guilty, and a conditional discharge is after being found guilty. So if that helps, that's what happens there for those two.
So Harold, I know that we've been talking about all these formal ways in which the law provides these opportunities for people, but Forsyth County has actually created its own unique form of a deferred prosecution, hasn't it?
It has, and it's called the Veterans Treatment Court, or Veteran Court Services here in Forsyth County. We're one of, I believe it's still 4 counties in North Carolina that do this type of deferred prosecution specifically for veterans. So it's set up a lot like a drug treatment court in that, if you're a veteran, no matter what crime you're charged with, you can potentially be part of this court and potentially have your charge dismissed depending on what it is. So, and of course, it's a lot of counseling and a lot of other stuff that veteran would go through, but it's a really, really important court we have here. So thank you guys for joining us, WTOB listeners, on For the Record with Greenwood Law. We hope that you got something out of this episode, and we hope you join us next time.
But before we go, do not forget that Greenwood Law Bill of Rights, and that's first and foremost, I will not represent myself in a court of law. Second, I will not do law enforcement's job for them. 3, I will not make statements when stopped by law enforcement. 4, I will not consent to searches when stopped by law enforcement. And 5, I will not be my own star witness for the prosecution. It's not a crime to know your rights, to assert those rights, but most importantly, stay safe out there, WTOB listeners. This is For the Record with Greenwood Law, signing off.